Welcome to Together for Justice, a tribal and state legal advocacy tool. This resource from the Native Alliance Against Violence, the Seminole Nation Domestic Violence Program, and the Oklahoma Access to Justice Foundation was created to equip advocates and survivors with plain language legal information and tools to navigate Oklahoma's complicated court landscape. In this video, we'll break down the rights survivors have, the responsibilities of landlords and housing programs, and the practical steps you can take to support safety and housing stability. Every day in Oklahoma, tenants who are also experiencing domestic violence face a difficult choice: stay in an unsafe home or risk losing housing altogether. The current rental landscape compounds the issue. Rental prices in the state continue to increase while minimum wage remains at $7.25 an hour. In fact, a person working at minimum wage would have to work 93 hours per week, more than 2 full-time jobs, to afford a modest one-bedroom rental at fair market rate in Oklahoma. If you're experiencing domestic violence, whether you rent from a private landlord, live in tribal housing, or use a housing voucher, there are specific protections that may help you stay safe, stay housed, or make a safe move without penalty. Housing can fall under federal, state, or tribal jurisdictions, depending on who owns or manages the property. Let's take a look at the different protections found in federal, state, and tribal laws. At the federal level, survivors of domestic violence have special protections under the Violence Against Women Act, also known as VAWA. VAWA applies when a survivor is benefiting from federally funded housing programs including HUD's Housing Choice Voucher, formerly known as Section 8, public housing, USDA rural development housing, and tribal housing programs funded through the Indian Housing Block Grant. This law says that survivors cannot lose their housing or be denied housing because of the abuse they've experienced. Some of the key protections under this act are: landlords and housing authorities cannot evict, terminate assistance, or refuse to rent or renew a lease to an applicant or tenant because they are a survivor of domestic violence. Additionally, survivors can request an emergency transfer to safer housing. Lastly, landlords and agencies must keep survivor information confidential. Federal protections are only part of the puzzle. Survivors in Oklahoma also have rights under state law that may help support safety and stability. If you're looking for a general overview of tenants' rights in Oklahoma, check out the Tenant Toolbox, a public legal information tool that covers issues Oklahoma renters face. Now let's take a look at specific protections survivors have under Oklahoma landlord-tenant laws. These rules can help a survivor break a lease early, keep a landlord from discriminating against a victim, or help get utilities turned on at a new unit. Under the Oklahoma Residential Landlord-Tenant Act, a victim of DV, sexual violence, or stalking may terminate a lease without penalty. To accomplish this, the tenant must give written notice and proof of a protective order within 30 days of the incident. Additionally, public utilities are required to waive opening deposits or special credit requirements for DV survivors as long as they can provide proof of the abuse, like a protective order or a statement from law enforcement or an advocate organization. Tenants who are utilizing a housing choice voucher through a local public housing authority have protections under both VAWA and the Oklahoma Residential Landlord-Tenant Act. Together, federal and state laws create a strong framework for housing safety. But in Oklahoma, many individuals are also covered by tribal housing rules. Let's take a look at protections under tribal housing laws. Tribal governments have the inherent authority to draft their own civil codes, housing policies, and DV-specific protections. These protections may vary by tribe, and the best way to know is by looking directly at the tribe's landlord-tenant code, domestic violence code, and tribal housing authorities' policies and procedures. Survivors who use housing vouchers administered by a tribal housing authority or who live in tribal housing funded through federal programs also have protections under VAWA. Know which laws apply. Checking the specific tribe's codes is the key to understanding exactly which protections apply. There is an additional avenue for housing-related support for survivors. When someone is fleeing an abusive relationship, they may not think of themselves as homeless. But under federal law, there are 4 categories of homelessness, and one is fleeing domestic violence. This includes any individual or family who is fleeing or is attempting to flee domestic violence, has no other residence, and lacks the resources or support networks to obtain other permanent housing. Here, domestic violence includes dating violence, sexual assault, stalking, human trafficking, and other dangerous or life-threatening conditions related to the violence that causes the victim to be afraid to return to their primary nighttime residence. Persons who meet the federal definition of homelessness because they are fleeing domestic violence may qualify for services like emergency housing, rapid rehousing programs, or priority access to vouchers. Key takeaway: no matter where a person is living in Oklahoma, there are legal protections meant to keep survivors safe. Remember, tenants who are also experiencing domestic violence may find protections under federal, state, or tribal laws. Fleeing domestic violence may meet the definition of homelessness under federal law, and understanding these differences will help advocates and survivors navigate to stable housing. Thank you for joining us for Together for Justice, Tribal and State Legal Tools for this quick introduction to domestic violence and housing. Please join us for other videos in this series. This resource is for education and legal information purposes only and is not legal advice. Laws and remedies may vary between state and tribal courts. Advocates and survivors should consult with attorneys for case-specific guidance.